I'm handing you what's been marked for identification purposes as Defendant's Exhibit 107. Do you recognize that document?
Yes.
I'm sorry, we moved my microphone and I need it back. I'm sorry, I thought y'all were going to be at the back. I still need that.
Yeah, this one.
Thank you, sir. Go ahead.
What is document 107?
An agreed suspension.
And you agreed to it, correct?
Yes, I did.
And you were given a contemplated indefinite suspension, correct?
Yes.
And what is a contemplated indefinite suspension?
Termination.
All right. And the agreed suspension was modified? You didn't get an indefinite suspension?
No.
What was the length of suspension?
1 day.
All right. And would you agree that when you signed this, you agreed to it?
Yes.
And you agreed to waive any right to appeal this agreed suspension and agreed that no administrative or judicial body shall have power to review this agreed suspension or alter the terms of this agreement?
Yes.
And you agreed with the alleged rule violations, correct?
Yes.
And you agreed with the factual allegations, correct?
Yes.
And so you were accused of failing to follow Procedure 607 and Procedure 707, which deals with crash investigations, correct?
Yes.
And the factual basis for the suspension was that you failed to investigate the collision properly and was untruthful on information you supplied on your accident report as follows, causing significant problems for the drivers involved and eventually requiring corrections to the accident report she prepared. 1, you failed to check all parties involved for warrants, failed to collect any evidence from the crash site, and failed to remain at the scene until all vehicles were removed. 2, Officer Platt is observed on Coban dash camera video allowing a vehicle involved in a public property traffic crash that is not drivable and a traffic hazard to be released to the owner in lieu of impounding the vehicle. Officer Platt is overheard telling the owner of the wrecked vehicle she has to tow the truck if she remains on scene, but then tells him he can remove the truck as he pleases if she is not present, improperly abdicating herself of any responsibility for having the vehicle properly towed, correct?
Yes, that's what it says.
And that was true, correct?
Yes.
Judge, we offered Defendant's Exhibit 107 because the credibility of a witness is inherent into the presentation of a defense. And what this document says is that she has been untruthful and has failed to do what's required by policy and has failed to properly investigate reports. And she has put into issue her belief that she's not required to do a complete investigation by the answers to her questions, that it wasn't her job to investigate the totality of the circumstances, that it was Detective Soto's. So we think this is relevant to show that her answers were incomplete, inaccurate, and untruthful.
Your Honor, the state objects. Under 608, as counsel has said, he wants to attack the witness credibility for truthfulness. 608A specifically requires testimony by a witness with knowledge. 608B prohibits impeachment with specific instances of conduct, which that document literally is. It is also hearsay. Along with that, I would also add to the court, if you even were to go forward to 609, impeachment, if it were a criminal conviction, you could not use it if it were 10 years old. I note that incident is alleged to have occurred May 10th of 2015. We are now in the end of October of 2025. It is too remote. There is no testimony to support any attack on her credibility, and it is a singular, specific instance of conduct which is prohibited by the rules of evidence.
Your Honor, may I respond?
Okay.
Well, 613 says specific instances of conduct come in to show bias and motive. And what I want to remind the court of is this witness went out of her way to say she didn't watch any body cams. That the only thing she knew about this case was what Sergeant Flores had said in his statements. And yet, when she's being cross-examined by Mr. LaHood, just, spontaneously says, oh, well, this, if there's obstructions, like a glass door with wooden panes, if there's a wall, if there's an obstructed window, exactly what we're dealing with here. So I think she has directly put her credibility into issue, and we're allowed, under our right to defense for all three of these officers, to put this particular witness, and then when she's primed, I know why they were indicted. So we're certainly entitled to go into her bias and motivation in this particular case with this evidence.
May I respond?
Additionally, Your Honor, Texas Rule of Evidence 406 talks about habit, routine, and practice, and what the state essentially did was talk about her habit and practice and routine when she investigates cases. So what we're allowed to do is to refute that habit, practice, and routine to show that it isn't her habit, practice, and routine to follow certain protocols of investigations because she didn't do it before. And it also shows that she was untruthful. So, it's also permitted under B2 because it's for the purposes of proving absence of mistake or lack of accident. Under B2, absence of mistake and lack of accident, she did a sloppy job in this investigation on purpose and is denying that this was an accident or she's not required to do it. So it's essential for us under B2 for us to be allowed to, in a criminal case, to use it for permitted use.
First, Your Honor, 613B2 specifically relies on a written statement to show a witness's bias or interest. I understand that is a report from the Internal Affairs reviewing the agreed discipline.
It's not from Internal Affairs, it's from the Chief of Police.
It doesn't have to be a written statement either. That's
I'm reading the rule verbatim.
All right, let's let him argue, and then once we're done arguing, then the defense can argue.
Along with...
I'm looking at the rule as well, so.
Yes, sir. Along with, if it were allowed, 613B4 requires the evidence of any bias is not admissible unless the witness is first examined and then fails to admit. She, as the court heard, she was presented with this from Mr. Cifuentes. She did not deny it. She acknowledged it. I don't believe the criteria laid for impeachment, particularly to get it in front of this jury, has been met.
And, Your Honor, bias and motivation are always relevant and admissible in any trial for purposes of due process and confrontation in the compulsory process clause of the Sixth Amendment.
But not with hearsay, Your Honor. It requires testimony.
And this is not hearsay because she admitted that she engaged in misconduct. She admitted it. And by signing this document, she agrees that it's all true. So if she agrees that it's true, the witness has admitted that this is true. And it can't be hearsay.
At which point then, if she's admitted to it, then there is no confrontation by the 613.
What was the suspension for specifically?
For untruthfulness.
That was not. That was not.
Judge, will you examine the document?
Yes.
That was
It
not.
says that she was untruthful here.
That's in the details. That's not the actual.
If it says that she was untruthful, then she was untruthful. And she agrees that she was untruthful.
State, what's your understanding that the suspension was for?
I'm reviewing it right now, Judge. Scroll back to the top.
So what I'm reading is that it says failed to investigate the collision properly and was untruthful on information she supplied on her accident report as follows. Causing significant problems for the drivers involved and eventually requiring corrections to the accident report she prepared.
Yes, sir. Yes, Your Honor, I'm reading that.
And it has number 1 and number 2.
Yes, Your Honor. And so again, as in the hearing, counsel asked the witness about it. She admitted to it. She did not deny it, as the rule requires in order to confront her in front of this jury.
Am I allowed to explain that?
Yeah, you want to ask the witness, so I can hear it from her?
Yes, ma'am. May I have the exhibit?
Yes.
Detective Platt. The incident that's referred to under Defense 107, what is it called up front?
It's called an agreed suspension.
And so an incident occurred, you were charged with violating department policy, correct?
Yes.
And you all agreed, did you admit to it when confronted by your superiors?
Say again?
Did you admit to it, the allegations, when confronted by your superiors?
For the agreed suspension. Now there were a few allegations. I don't remember all of them, but I know untruthfulness was one of them, and the reason why it was not that which made it a contemplated indefinite. The untruthfulness was not founded, and it was dropped to a 1 day. And so the board had agreed that the others, which was, I think, just these two, the part that you're reading was the factual basis for the instant disciplinary suspension as written by the IA sergeant. It says the violation of the policy were from, because you have to have the specific policy listed, and so the violations that were listed that I violated were impounding vehicles from the crash scene and crash investigation responding to crashes. That's what ended up resulting in the 1 day suspension, was those two allegations. The other allegations were not founded, and that was not part of the 1 day suspension.
So, Your Honor, and with that, I simply close again. It's titled agreed, which, just to my common understanding of the word agreed, does not mean she denied, evaded, and/or lied. I say again, it's not permitted, even under the fullest reading of 613, it's not permitted by 608, along with to impeach with, again, a specific instance of conduct. If this were a criminal conviction, it is too remote to be allowed to go before this jury. It should not be allowed to come into this trial.
Your Honor,
And Your Honor,
add one thing here, if I can. Evidence that a person has been untruthful, if she was, evidence of that is not admissible in court. The only thing admissible would be if they called a witness who was going to testify about her character for untruthfulness, or had an opinion about her untruthfulness. They can't come in and testify that, when she was 14, she lied to her mother about whether she brushed her teeth. And this rule says you've got to have somebody come forward and say, I have an opinion as to whether she's a truthful person or not. And then the specific instances of conduct can go into express what their reasons were. But this is clearly inadmissible.
So I guess the issue here is,
if I may address the court.
yes, I guess the argument from the defense, just to make sure I understand, the suspension would have to reflect bias or interest related to this particular case. Is that right?
Your Honor, my assertion is, if I may
Yes.
make the argument,
Yes.
she states in the agreement, Officer Platt waives any rights to appeal this agreed suspension and agrees no administrative or judicial body shall have the power to review this agreed suspension or alter the terms of this agreement. And she testified that she admitted that it's true that she failed to investigate the collision and was untruthful on information she supplied in her accident report. So it's germane to her functions and duties as a police officer in completing reports. What's at issue is whether or not she fully and accurately and fully investigated this case and included all the details of the totality of the circumstances, and what she is doing is blaming someone else. That's not my job. Like Chico and the Man, I don't know if you remember that, but it's, not my job. And you can't do that if you're a police officer, if you have a duty to fully investigate the case. And so this shows that when she says it's not my job, that she's being untruthful and failing to do her duties to do a complete, fair investigation. And that's why it's relevant.
And I just want to, and this is the last thing I'll say, Your Honor, is to protect the record from our perspective. Mr. Luna was talking about, well, if she was 14 and lied to her parents, we're not trying to go into that. We're trying to go into, was there a finding of her being untruthful as a police officer? With regard to their arguments under the rules of evidence, the court well knows under the Code of Criminal Procedure, the highest law in the land is our constitutional rights. Cases like Davis v. Alaska have shown, no, a person's constitutional right to confrontation overcomes a simple rule of evidence that says maybe you can't go in and impeach that juvenile. It's the same thing, Your Honor, with the line of cases we provided all United States Supreme Court cases, our right to defense. They all talk about when it comes to overcoming things like the rules of evidence, the defendants, these three gentlemen, their right to confrontation, their right to put this witness in perspective, they are on trial for their lives, overcomes, and like I said, I would still say bias and motivation are always relevant. That's black letter law. It's relevant in every case. And the bias and motivation doesn't have to be for this particular case. It's the bias and motivation of a party. She has clearly aligned herself with San Antonio Police Department, who rushed to indict these men without a full investigation. And once again, I just want to reiterate the fact that she was being disingenuous by saying, I don't know anything about this case, but let me rattle off this litany of what just so happened to be the exact facts of this case.
Your Honor, if I may, the witness testified that she was called in to support the primary investigator, Detective Soto. She had specific tasks to set up video and to take statements of one of the subject officers. She did that. She explained how she did it. She explained she wanted to get his word. She did not editorialize it, etc. To put on her the burden of looking at every other related video when taking the statement of one of the accused, it's unreasonable. The defense is trying to daisy chain all of these events, and it's unduly prejudicial. It is inadmissible. It is wrong. If they have testimony they want to bring in to try to impeach the witness's credibility, then do so. But that document before you says that she agreed to, and it's her own testimony, she was the one who was there, the allegations of untruthfulness were unfounded.
Okay, so is the defense trying to say that she failed to, right, obviously the argument is that she did not fully investigate this case. And she has motive somehow or another to cover up this investigation. It was in this particular case. And you're saying that this extrinsic evidence somehow or another shows that she failed to investigate this other case.
That's right. And she's also admitted in the factual narrative that she's untruthful. She admitted that that's true, that she admitted to it. So whether there's a finding of the rule violation, the fact that she admitted that she was untruthful is sufficient to show she was untruthful.
And then, Your Honor,
about fulfilling her duties to investigate a case.
and again, Your Honor, if that is in the document from 10 years ago and she does not deny it, then they can't try to impeach her with it. She has not denied it.
We're not showing it necessarily for impeachment, but to show that under 404B2 that it's admissible.
I think, Judge, if I may just respectfully make a suggestion, maybe if the court would consider talking about, have you ever been reprimanded before in general for being untruthful and how you handle an investigation without going into the specific instance of conduct? my humble suggestion, after hearing all the arguments, you're the judge, maybe that's something the court can consider, Judge, I mean, to kind of rectify this, because with all due respect, I mean, it does appear that she's testifying differently, and I'm going to recross her, don't get me wrong, but when she's talking about, I know exactly why they were indicted, now that she's put herself into a different category, she said, I've seen nothing. She said, all I did was take a statement, all I did was do this, and now she kind of took a different step. So I think Mr. Del Bravo is saying is she has aligned herself not with an investigatory role and being objective, but being subjective with the government's position and the brass's position, not the membership, but the brass, in our opinion, falsely accusing these officers. So yes, I can impeach her, I can cross-examine her, I understand that. But now we're not getting into a specific instance of conduct in general, saying you've been reprimanded for not being truthful in how you handle investigations. She is testifying to an investigation regardless of her role in it, and maybe that is something the court would consider, Judge. That's my humble suggestion.
So I don't want to take issue with Mr. LaHood, but I think that what is worse here and why it's so imperative is that her testimony puts her duties and responsibilities in front of the jury in a false light, as if that was not her responsibility, when in fact it is her responsibility to fully investigate the totality of the circumstances, because what she's essentially admitted is that since she didn't tell Soto and no one else told Soto, that somehow or another, and again, I hate to use Chico the Man, but she's telling them it's not my job. And that can't be the case. And what we want to show is that, yeah, it is your job and you should have known better. And by saying it's not your job, you're not being truthful and candid with this jury. And that's relevant for purposes of presenting a defense for our client, Eleazar, Alejandro, and others.
I have nothing else to ask Judge, but nothing else to add, Judge. Just, I don't believe she has admitted to it. I'll simply say that. Impeachment falls if she denies it, which she has not done.
All right. I'm sorry, you wanted to...
Well, I'm not saying we're trying to impeach her per se, Judge. Veracity is always at issue, Judge, with a witness. We all know that. Both sides know that. And so I think it's more in that vein. I understand what counsel's argument is, but we're not trying to quote-unquote impeach her specifically. It's veracity.
She's put herself in a false light, and we should be entitled to correct that false light. And I think that she essentially has opened the door by suggesting that she's never done anything wrong or incomplete in an investigation. If someone, she's essentially put her character into issue by saying it's not her job and she did a complete investigation. If someone were to say that I've never stolen before, and in fact they had stolen, then sure, the door would be open. So if she's opened the door, so when a witness opens the door to their prior bad acts, it's admissible. I think this court, on that basis alone, should allow this, because she's put herself in a false light, trying to say I did a complete, fair investigation, when in fact she didn't. And she knows better, and in fact, she has messed up investigations before.
Your Honor, and that's where counsel exceeds what he's trying to say. She never testified she did a full and complete investigation. She said her role was to take interviews of officers. One of them is one of the shooting officers of the OIS. She took two others, and she said, that is all I was tasked to do. She did not deny it, and then everything else counsel asked, if she did this, she did that, she responded, those were not my duties. On this case, as she was assigned by her leadership, she has not denied anything. If the court were to allow it, I would continuation or a nuance of Mr. Lid's suggestion, then maybe the question might be, have you ever done an incomplete investigation and or been disciplined for it? But I would still come back to she has never denied it, therefore there is no basis to impeach her with it.
Your Honor, the counsel's suggestion that somehow or another that there's no connection between her role in this investigation and this case is specious, and I'll tell you why. Procedure 707 is crash investigation, and she was a patrolman at the time this happened. She's not required under SAPD policy to investigate crashes. The traffic investigative unit, made up of detectives, is required to investigate. And so she takes part in the preliminary gathering of facts and information. And so there's an analogy to this case. What she's suggesting is that, oh, that was Soto's job, and so I can be incomplete, I can be inaccurate, I can have material omissions because it's Soto's job. That's the same thing that's happening here when she was charged with failing to follow Procedure 707 as a patrolman. She can't put herself in a false light. She has opened the door by suggesting that it's not her job, that she didn't do anything wrong, and she's not required to do a complete, thorough investigation and take a competent statement.
Your Honor,
That's why this should be admissible.
Your Honor, that is a blatantly ridiculous argument. The homicide unit works collaboratively, particularly when they have OISs. Detectives will come in, they're given different parts of that elephant to eat collectively together. She was doing her role. She said, this is what I was assigned to do. Had she been given additional assignments, I'm sure she would have carried them out. Along with, I'll still go back, it's over 10 years. If you were impeaching a witness in a criminal case, that is the nexus of too remote to bring up. It is an impossibility.
There is no time limitation when someone puts themselves in a false light. They have not addressed that she has put herself in a false light. She has opened the door by saying it wasn't her job, that she doesn't have to do a complete investigation. She's not required to look at the video. She doesn't need to do the totality of the circumstances. She has put herself in a false light. Because she's put herself in a false light, we're entitled to correct that. She can't put herself in a false light and then have the defense being unable to attack her credibility for putting herself in a false light.
All right.
Just one final, Judge.
Yes.
She has testified that her duties were to take statements, I believe it was Officer Neary, Defendant Flores, and there was one other person. And she set up interviews. My point is, she did those assigned tasks completely. They are not impeaching her because she did her assigned duties incompletely. They want to expand it when she was not the filing detective. She did not seek the warrant. She did not sign the warrant. She did not do anything other than the task she was assigned. And that she did completely and fully.
All right, so I've reviewed the law. If I conduct a 403, the prejudicial value is low. I think the probative value is low. I like the idea of splitting it. I'll let the defense ask her questions about it and only admit the document if it looks like defense. You can't do it without. You can't impeach her without the document. Her role was minor, so again, I'll let you ask questions about it, but at this particular point, I won't allow the admission of the document. Anything else?
Just for clarity, because I want to make sure none of us violate your instruction, Judge.
Yep.
So you're saying we can ask her about the suspension for untruthfulness in how she conducted an investigation, but not enter the document and leave it at that?
Yes.
Your Honor, again, if I understand that suspension, it was not for untruthfulness.
And you'll have the ability to redirect. Anything else?
Right.